Yes, Mr. Queen.
Morning, Lord. Lord, we understand you may not yet have hard copies of the transcript for yesterday. We are getting them for you.
Right.
They're on their way. We are looking at Article 7, as you may recall.
Yes.
And Article 7 is B11, 145 to 6. And I am now on point 3 in relation to Article 7. Which is picking up on text at B11, 146. And the heading to point 3 is Articles 7.3 and 7.7. And the point is simply this, that Article 7.1 imposes a freestanding obligation, is reinforced by Article 7.3, which, though drafted in the negative, contains a clear reference to the obligation to make contributions, which arises under Article 7.1. And this is all part of the process which I'm trying to anchor for your lordships, the basis upon which you're going to make your decisions in relation to Article 7. And this point that there's a freestanding obligation unique to the employers is reinforced further, as we've already seen, by Article 7.7 over the page at B11, 147, the Schedule of Contributions provision, which requires the actuaries, so soon as reasonably practicable, after advising for the purposes of Article 7.1, to provide a schedule of the employer's contributions so required. It is the additional employer contributions required under Article 7.1, which are the subject of the Article 7.7 schedule. Article 7.1 is only providing an obligation for employers to make the sufficiency of funding payments, and Article 7.7 relates to that. Point 4. Articles 7.4 and 7.5. It is further plain from other provisions of Article 7 that Article 7 generally is providing additional rights and protections in relation to protected persons over and above that which is provided for under the rules of the RPS. And that the appellant's now rather distant option A suggestion that the RPS already satisfies Article 7 is inconsistent with that. First, Article 7.4, which has from the outset in 1994 imposed on employers a balance of cost, not a shared cost obligation, to top up transfer values in respect of protected persons' relevant pension rights. The Article 7.4's significance is twofold. Its significance is not only that it enacts an obligation which plainly is not provided for in the rules of the RPS, thus giving the lie to the proposition that the RPS is without more Article 7 compliant. But the second point is that, like Article 7.1, it is plainly providing for a balance of cost obligation on employers in relation to protected persons, notwithstanding the template shared cost nature of Rules 3A and B. And secondly, then, there is Article 7.5, which we looked at in detail in connection with Rule 21, which, as we've seen, provides that the trustee cannot increase contributions of protected employees or reduce the benefits of any protected person unless the actuary advises the trustee that such increase or reduction may or should be made. And its significance is twofold. First, likewise, it confers a substantive role for the actuary, which plainly is not provided for in the rules of the RPS, thus again giving the lie to the notion that the RPS is without more Article 7 compliant. But it's the second limb of its significance is, as we saw yesterday, that it provides an insight into the actuary's determination role under Rule 21.1. Point 5. Sufficiency of funding, which is lies at the heart of Article 7.1's obligation. Sufficiency of funding is not provided for under Rule 21. It is plain that Article 7.1, as introduced in 1994 and continuing applicable today, in providing a sufficiency of funding obligation, is providing for an obligation not found in Rule 21 at all. The fact is that, as we've seen, and I don't want to go back to this in detail, but as we've seen in our discussion of Rule 21, but we can now return to briefly here, employers of protected employees never had a sufficiency of funding obligation under Rule 21. It's only by looking at Article 7.1 that one finds it. It's Article 7.1 that provides for it. In fact, Rule 21 never purported to impose a sufficiency of funding obligation on employers whilst there are active members at all, not as at 1994, and not in 2006, and not now. And indeed, as originally drafted, as we know, as it stood between 1994 and 2006 in the Atos Section, Rule 21 did not purport to provide a sufficiency of funding obligation on employers where there were no active members either. And whilst a balance of cost obligation was belatedly introduced into the Atos Section in 2006 to address a situation where there might be no active members by a new Rule 21.13, Article 7.1 had been in place since 1994, and its meaning did not change in 2006 as a result. And as we know, even now in 2023, Rule 21.13 doesn't apply to the present case. So putting it to one side, the absence of the employer's sufficiency of funding obligations under Rule 21 may be seen as follows. As your lordships will have noted, since 1994, there only ever have been 2 employer contributions provisions under Rule 21, where a section has active members. First, under the STEM, but employers have no and have never had a funding obligation, let alone a sufficiency of funding obligation under the STEM. Under the STEM provides for whatever might be agreed between the designated employer and the trustee. It doesn't anywhere require agreement. And the second place where there is an employer contribution provision in Rule 21 is, of course, Rule 21.1.2. But such funding obligation as might, underline might, be imposed on employers is, and has always been, subject to the 130% cap. The 130% cap on the employer's 60% of the future service funding rate, which employers are under no obligation to agree to lift. So there is no sufficiency of funding obligation on employers under that provision either. And certainly none under 2 which places a distinct obligation on the employers alone to provide a sufficiency of funding. So such funding obligation as there is in 2 is the lockstep. It's not the sufficiency of funding obligation which Article 7.1 is contemplating, which is an obligation on the employer alone. There are then, moving on, there are then 2 further reasons why it is plain that Article 7.1 imposes an additional obligation on employers under the RPS, and that is going to be the subject of my points 6 and 7. Point 6 is the redundancy point, and it's this. Under Rule 3A, we don't need to turn it up, you've looked at it, but it's B13207. Under Rule 3A, employers already have a covenanted obligation to contribute in ongoing and shortfall circumstances. As you've seen, 3A cross-refers to 3B, and 3B deals with both the ongoing and the Rule 21 adjustment situation. 1.5 multiples provided for. That Rule 3A duty, having been contractually provided for under Rule 3A of the RPS, and being a duty already imposed on the employer as a result, it was not necessary for there to be a statutory instrument repeating that. So, quite apart from the fact that neither Rule 21, nor for that matter Rule 3A, provided for employers to owe a sufficiency of funding obligation, there is the point that Article 7.1 would have been providing nothing of substance if it was merely reenacting that which it was provided for in Rule 3A. And the second point, point 7, under the general heading of there being further reasons why it's plain that Article 7.1 imposes an additional obligation on employers under the RPS. Point 7. Point 7 is this: protected persons are not only active members. And you've seen that let me make the point more slowly. Article 7.1 applies and has always applied since 1994 wherever there are protected persons in a section, irrespective of whether they may be actives. And so Article 7.1 has applied irrespective of whether Little Roman numeral Rule 21.1.2 or Rule 21.1.4 could ever have applied. Article 7.1 has always, since 1994, stood behind the shared cost arrangements, making sufficiency of funding provision in relation of protected persons, irrespective of whether there are any active members in the section whose contributions could be affected under 2, or whose future service benefits could be affected under 4. Protected persons, naturally enough, as you'd expect, include pensioners and deferred pensioners. You don't suddenly lose the protection of your pension rights once you become a pensioner or a deferred member. Protected person status is enjoyed as a result of having had protected employee status immediately before the passing of the Act. And for your note, that is the protected employee status derives from Schedule 11, Paragraph 5 of the Railways Act, B10113. And what was then protected in relation to those persons ascertained at that moment in time was their relevant pension rights. And relevant pension rights, as we see from Schedule 11, paragraph 6.3 of the Railways Act, that's B10 114 to 115, the relevant pension rights of protected employees as so ascertained meant and means, first, any rights accrued under the predecessor nationalised scheme to be transferred into the RPS, and second, any rights continuing accruing through participation in the joint industry scheme, the RPS. And additionally, Schedule 11, Para 5D of the Railways Act, back to B10 113, tells you that protected persons include any persons taking in consequence of the death of any other protected person. So the status of being a protected person is in no way dependent on being an active member. It is a status which derives principally from the fact that you were a protected employee at the moment of at the moment of the Railways Act being passed for the purposes of denationalisation, and that thereafter that status continues to be enjoyed in relation to accrued and accruing rights, whether you retire or not. Indeed, it would be monstrous if you lost your protection the moment you retired, because that's probably the most important moment of your pensionable life. So a section could, at any point after 1994, have come to have had no actives. Because, to take the example that my learned friends put in their skeleton, a section could cease to have actives because of a TUPE transfer. And in that circumstance, there would be no scope for shared cost contributions under Rule 3A and Rule 3B, or 21, 1, 2, and 4. And yet the sufficiency of funding obligations under Article 7.1 would have existed in that circumstance. So those are the two redundancy points sorry, forgive me. Those are the 2 points demonstrating the additional layers of protection that Article 7 is clearly there to provide. It's not there simply to restate that which is already there under Rule 3A, that's point 6, and it's clearly there to confer protections by way of security of funding in relation to protected persons who have no such protections under Rule 21 or Rule 3A and Rule 3B once they are no longer active members. Point 8, common ground, the new G point. So referred to at...
a single pool.
I'm so sorry?
A single pool.
A single pool. Your Lordship said. Employers had the option at the time of privatisation to separate protected persons from non-protected persons. They could have done it. They could have said new joiners are going into a different section. They didn't. And as the Chancellor observed, it wasn't difficult to see why they didn't, because there was a surplus and because it was cheaper to do it the way they did it. But that decision, no shame in that decision, entirely rational, has consequences 30 years on. It's a non-segregated section. If you're going to make sufficiency of funding provision for protected persons as a matter of iterative arithmetic, you have to make sufficiency of funding provision for non-protected persons as well. And as your Lordships know, it's common ground between us. The point was well, first ventilated in a courtroom and accepted in PNPF and Taylor, at D116 290 at pages 162 to 167 and accepted at, paragraphs 162 to 167 and accepted by Mr. Justice Warren at paragraphs 169 and 186. But whilst ventilated in PNPF and Taylor, it was a point that was around before PNPF and Taylor, as it were, in the advisory zeitgeist.
It's obvious.
Thank you. In that case, point 9. We can deal with this pretty quickly. At paragraph 56 of the appellant's skeleton, B9117-118, we've got a further leg of the option A argument.
I'm sorry, that was paragraph
56
Thank
of
you.
the skeleton.
No.
In a sense, we're flogging a dead horse here because option A. But what I'm trying to do is, as I say, is to anchor the basis of saying Article 7 does apply in this case for the purposes then of whatever decision your lordships make. The point there made by the appellants was that Article 7.1 was only concerned with ensuring proper actuarial scrutiny, and the short answer to that is that it is plain from reading Article 7, as we have done, that Article 7 is not simply concerned with proper actuarial scrutiny. It's concerned with imposing an obligation on employers of a sufficiency of funding character. You can't sideline Article 7.1 by suggesting that simply because the actuary would be doing his job properly in certifying what's required as a matter of sufficiency of funding, that is what Article 7 is exclusively concerned with. Point 10. There is then the point, and again, it's fallen by the wayside, but let's just quickly deal with it. The point that the appellants were making, that if Article 7.1 and 7.2 and 7.3 and 7 have the effect contended for by the trustee, in disturbing the balance of the shared cost structure to the extent of imposing a balance of cost liability, it's remarkable, the appellants have hitherto contended, that that's not set out in the body of the RPS. Now, yesterday, as I was endeavouring to submit to your lordships, it's not so remarkable even as a matter of practicality as to how the RPS is going to work, because there will be many, many circumstances where you won't get to Article 7, where it's perfectly possible, either through the operation of Sub-Rule 2 or through the operation of Sub-Rule 2 in conjunction with Sub-Rule 4, to get to a conclusion where the shortfall is made good in full as a result of the operation of those provisions. Collectible contributions having been set, value for money issues having been navigated under 4, so that there's no question of no collectability. And I'm coming back, of course, to the question of when Article 7 cuts in making that point. So, but we had this point yesterday. It's perfectly clear that it's possible for the default provisions under 2 and 4 to work without Article 7. It's perfectly possible for the default provision under 2 to work without Article 7. And it's certainly possible for the STEM agreement to work without Article 7. So the notion that Article 7 is in some way fundamentally subverting the shared cost template is an overblown proposition. It's doubly overblown because agreements under the stem, almost by definition, will depart from the shared cost template provided for under the rules. Almost by definition, you will depart from the 60-40 shared arrangement, with employers taking more of the hit in order to enable the shortfall to be addressed. And you'll recall that in the 310 examples referred to by Mr. Hannon in his witness statement, what he said of them at paragraph 45 of Hannon 1 was that in all those cases, the 60-40 ratio was departed from. The employers, as it were, did the decent thing. They stepped up and said, okay, look, we've got a shortfall. It needs to be addressed. Let's address it by having a sensible range of contributions for the members, and we'll pick up the balance. And why might they do that? For any number of reasons. But the possibility of Article 7 standing behind the negotiation was a particularly good one.
And Mr. Green, would you say also that a reason why Rule 21 may not was drafted in a way which doesn't make express reference to Article 7 might be that Rule 21 has to exist also in circumstances where there are no PPs?
Exactly. And indeed, my lady, absolutely. And in fact, excuse me, I distracted myself by reverting back to the discussion yesterday concerning Rule 21 being capable of perfectly sensible operation without getting to Article 7. I distracted myself from the proposition which your ladyship has just commented on, which is proposition 10, which is why is it, answering the question, well, why is it that Article 7, if it's got this potentially significant reach, isn't in the rules? And the answer to that is that it's no more surprising in relation to Article 7.1 that it's not in the rules, than it is that none of the other provisions in the 18 pages of the RPS, in the 18 pages of the protection order, B11, 139 to 157, which are not set out verbatim in the RPS, are not there. And you start, as we've seen, with Articles 7.4 and 7.5. They're not included in the body of the RPS, and yet they plainly apply to it. But the proposition is capable of extension across provision after provision in the protection order. And as we've observed many times before you, and as is common ground, it's been observed on more than one occasion by my learned friend as well, the protection order was always drafted in parallel with the RPS order, setting out the trust deed and rules. It was always to operate alongside them. They were brought into effect on the same day. Effectively, you'd have the trust deed and rules in your right hand and the protection order in your left hand. And the bridge between them, if you needed one, was always clause 7H of the trust deed, which said, by the way, don't forget you've got to look at the protection order. And anybody from 1994 onwards was clearly going to be, would have them both on their desk. And then, as
and you would also say that the casual reader, obviously there are lots of casual readers of this, in 2013 or 16 or 23, would know that the protection order was also relevant because of clause 7H.
Indeed, and there are one or two other references to it in the provisions of the scheme. I mean, it is mentioned. It's just not laid out. You know, exactly. But I would say that. And then I was going to come to make the point which your ladyship immediately made, that the Railways Pension Scheme was there to provide benefits to non-protected persons as well as protected persons. And as we've already noted, separate sections could have been set up for non-protected persons. And even if they were not originally, I can tell you that since 2007, 7 new shared cost sections have been set up which don't have any protected persons in them. Now, that's just a fact. But it doesn't affect this construction. But people have done it since the imperative to do it in relation to protected persons and the existence of the surplus and the, as my learned friends have said in their skeleton, that is it almost the easy choice of going for the pre-pack in 1994. Since that's receded, employers have, in 7 of the 106 cases, decided, well, we'd actually quite like to have our employees in the Railways Pension Scheme, but we don't have any protected persons. We'll just set up one which is clean as a whistle. And in that case, Article 7 and the whole of the protection order's got no bearing at all. But even if you didn't set up a separate section, the point is this.
Sorry, please may I just understand, if you set up a separate section, you don't take the model rules either.
Oh no, what's happened is that people have said, thanks very much, we'll take the normal rules. They've adopted the shared cost arrangements.
Right. But
in relation to people who are not protected employees, new joiners.
Yes, but it still is the same rule. We will find 21 there.
Oh yes. Oh yes. Yes. No, that's correct. Yes. But then there's this further point, and it does apply to this case. Obviously, your cohort of protected employees, in due course, they become protected persons who are not active members. Some of them pass away, and their relatives who take benefits under the scheme are also protected persons. But they are joined by new joiners, as has happened in the Atos case, up until 1999 at least. They are joined by new joiners. And those new joiners are not protected persons, as we know. And so all the protections in the protection order don't apply to them. Happens that they get the benefit of the new G point, but all the protections as to amendments, as to no less favourable benefits, don't apply to them. And so you can be in a situation which exists in other sections, not in the Atos section, where you've got, as it were, subsections which are not segregated, which have different benefit characteristics for different people. The protection order is then applying to some but not to others. These are all possibilities, but the true position is, from 1994 onwards, everybody's got them both on their desk. If you've got protected persons, you've got them both. You've both got them both on one desk at all material times. And so we say that the non-inclusion of the protection order actually in the body of the RPS makes and made perfect sense for all of the, as it were, the above reasons. You know, Article 7.1 certainly was not going to apply on a daily basis in sections. And indeed what's happened, of course, is that as time has moved on, as deficits rather than surpluses have become the issue of the day, and at certain times in the past, it's beginning to reconcile itself now, deficits were a very, very serious business, yeah? And as the numbers of active members have contracted in sections, over time, the Article 7.1 issue has become more pronounced. But Article 7.1 has always been there, and it's always had an effect. And that's what's brought us to these proceedings. And it's interesting, just as a small aside in relation to this, that the government guarantee in relation to pensioners wasn't included in the pensioners section either. I mean, it was referred to as existing in the pensioners section, just as clause 7H refers to the protection order. But if you want to know what the government guarantee consists of, you've got to go away and you go, and I've seen it, it's not in evidence before you. As you might imagine, it's a document, it's in fact 13 pages of a single-space document with actuarial assumptions in it, and et cetera, as to what the nature of the solvency guarantee actually consisted of. The fact that you don't find it set out verbatim in the pensions section of the Railways Pension Scheme doesn't mean to say it doesn't exist and have effect. And the same is true, as we say, of the 18 pages of the Pet Protection Order. Point 11, the no less favourable benefits point. This is, again, a complete red herring, we say. I mean, again, it's of no, it hasn't got any legs once option B is accepted. But the notion that the no less favourable benefits issue in some way affects the construction and application of Article 7.1 is a total fallacy. It's common ground, this paragraph 11, sorry, point 11, it's common ground that the benefit structure under the RPS would have been designed to be compliant with the obligation to provide a scheme or section providing for no less favourable benefits in relation to protected persons under Article 4 of the Protection Order. That's, as you've seen, Melenford took you to it, B11, 142 to 143. That is not in doubt. But it's irrelevant to the present issue because we're here concerned not with benefit structure, but with funding. And funding and benefits are different matters. But I've already laid the ground for this point in my points 1 and 2 yesterday. As we've already noted, each funding and benefits, each is separately the subject matter of protection authorised under Schedule 11 of the Railways Act. No less favourable benefits are the subject of prospective protection under Schedule 11, paragraph 6.2, as we saw yesterday, of the Railways Act, B10114. So no less favourable benefits are the subject of the no amendment, no prevention of participation, and no detriment on winding up protections in entertained in paragraph 6.2. The duties to fund are to be found in Schedule 11, paragraph 7.1f of the Railways Act, as we saw yesterday, B10117. And each of the no less favourable provision in 6.2 and the duty to fund under 7.1f, as we saw yesterday, were expressed to be without prejudice to the generality of the overall protection provided for in Schedule 11, paragraph 6.1. And as we saw yesterday, there were matters in Schedule 11, paragraph 7.1, which had been covered off in Schedule 11, paragraph 6.2 on a no less favourable basis, but were nonetheless potentially subject to further and additional protection. So not only are funding and benefits as different matters recognised in the Railways Act, but as we've seen, they're recognised as different matters subject to separate protections in the Protection Order. No less favourable benefits are the subject of Article 4, the obligation to provide a no less favourable scheme. Article 5 the prohibition of or prevention of participation or acquisition of relevant pension rights under a no less favourable scheme. And Article 6, amendment, transfer or winding up not adversely to affect no less favourable rights. Sufficiency of funding is separately provided for under Article 7, again in language which makes no reference to the no less favourable concept. And as you know, just because as regards benefit provision, the RPS may be taken to have met the minimum baseline of no less favourable standard required by the protection order, that plainly does not prevent the RPS being more favourable as a matter of benefit structure than the BRPS, let alone prevent the RPS being more favourable as regards funding than the BRPS. If indeed, given the implicit HMG guarantee behind the BRPS, if indeed Article 7 can be said to be more favourable. And indeed, as a slight sidebar point on this, just behind the Rule 45.5 BRPS debate, it is to be borne in mind that that HMG was standing behind the British Railways Board, and although the actuary was enjoined under Rule 45.5 to reset contributions on a 60-40 basis to address a deficit so far as necessary, the notion, particularly in the highly industrially organised railways industry in the late 1980s, that the government would have permitted a situation where the actuary was imposing, without any 130% cap provision, 75% contributions obligations on members under that provision, is pie in the sky. I mean, that provision would never have remotely operated so as to create collectability issues. Sorry, it's a sidebar, but it's a bit of realism. I mean, it's a further point as to why looking at the rules of the BRPS and saying, well, carry the underlying thoughts behind implicit in those rules across to the RPS is actually fallacious. But as we say, it's perfectly clear that no less favourable benefits and more favourable potentially funding are quite different kettles of fish. And as I was just saying before, the BRPS excursion, the fact is that in Article 7, in reality, was not giving to ex-British Rail employees the same degree of security as they had when they were employees of British Rail, because they were going to be subject to the vagaries of the covenants of the privatised employers who might in due course take them on. So point 12, in summary, the takeaway points from what we've said so far, if you like, the headline points, are these, and that very shortly, just drawing it all together. And they are 5 very short ones, single sentences. 1, Article 7 is clearly doing something over and above what is provided for in Rule 21 of the RPS. 2, what Article 7 is doing is imposing contributions liabilities on employers and only on employers. It's Articles 7, 1, 3, 4 and 7. Point 3. Those liabilities are balance of cost in character, specifically in the case of Article 7.1, a sufficiency of funding obligation on the employer, which is freestanding, as contemplated in Schedule 11, Para 7.1f of the Railways Act. Point 4. Article 7 so provides, in effect, in relation to any section with protected persons, a solvency assurance akin to the government guarantee in relation to ex-BRPS pensioners and deferreds. The accrued rights of each category of person equally meriting protection post-privatisation. And post-privatisation accruing rights of protected employees equally meriting protection, because those accruing rights would have had the benefit of the government guarantee had privatisation not occurred. It's a matter of real politics to recognise why relevant pension rights, when defined, included not merely accrued rights, but accruing rights. And point 5, Article 7 makes clear through Articles 7.4 and 7.5 that it is imposing obligations which are not contained in section rules, so reinforcing the point that Article 7.1 is doing so also. And that essentially is the trustee's positive case on Article 7. It's why option B is essentially right in that in saying that Article 7.1 cuts in after Rule 21 has operated to the extent that it is able. Can we come back to the trustee's supplemental skeleton point of yesterday? And that the issues really between us, as I said to you yesterday, are one, whether the, as it seems, the appellants wish to take credit against the £18.1 million of Article 7.1 deficit for contributions of £0.9 million under Rule 21.1.2, and for the reduction in future service liabilities of £5.3 million, even though they do not reduce the £18.1 million at all, the point which I introduced to you yesterday by reference to the scheme actuary's report. And we say that that's cloud cuckoo land if that you haven't addressed the deficit, and the sufficiency of funding obligation under Article 7.1 clearly applies to the whole 18.1 million. You can't take credit for that which has not actually been provided. And the second issue is the one which I'm now going to come on to, which is where does Article 7.1 cut in? And as regards that, as you know, the trustee has been, and forgive me for using the word, relaxed on this issue. We have been relaxed on it. And we've been relaxed on it. We signified that relaxation before the Chancellor. We repeated it in our skeleton before this court. And that degree of relaxation appears from paragraphs 17 and 74 of our skeleton before this court, A10138 and A10152. But the point was put a little bit more fully for the benefit of your lordships in paragraph 12 of our supplemental skeleton, which, if I might please remind you of it, it's A13153.14, A13 at page 153.14.
Could you repeat which paragraph, please?
Yes, it's paragraph 12.
12, thank you.
Yes. The trustee has approached this subsidiary issue on the basis that either is a possible interpretation.
Yes, don't read it out, Mr. Green. We can read it, and it is, as you've just pointed out, the third iteration of the same point.
Now, the submission before the Chancellor was that Article 7.1, being concerned with the sufficiency of contributions to meet accrued and accruing benefits, most naturally came in after Rule 21.1.2, which was concerned with contributions and not after 4, given that if Article 7.1 only cut in after 4, the secure funding assurance for accrued and accruing benefits, as per Article 7.2, would be subject to practical erosion. Now, the trustee sees the counter-argument that a prior operation of 4 might be an Article 7.1 relevant matter. Article 7.1 B 11.146 shall be sufficient to make provision in respect of the rights specified in paragraph 2, the accrued and accruing rights, after having taken into account all of the relevant matters, including the resources of the scheme or the section and any employee contributions. So the trustee sees the counter-argument that a prior operation of Rule 21.1.4 might be an Article 7.1 relevant matter, such that account is to be taken of the effect of future service benefit reduction before the ultimate sufficiency of funding obligation is imposed under Article 7.1. However, bringing a reduction of future service benefits into account by virtue of the operation of 4, of Rule 21.1.4, on the basis of the unspecific reference to relevant matters, might be said to invest those matters with a significance, those words with a significance, which their use does not directly and certainly not explicitly immediately convey. In other words, it is to beg the present question rather than to answer it. After all, the draftsman had expressly said in Article 7.1 that employee contributions, the subject of little Roman numeral 2, should be brought into account as a relevant matter. And that, as I say, would cover, employee contributions would cover any additional employee contributions under 2. So whilst a possible operation of 2 was catered for expressly, a possible operation of 4 was not. The draftsman could easily have said that reductions of benefits should be brought into account as a relevant matter if he had had 4 in mind. Especially, as we say, the sufficiency of funding of accrued and accruing benefits was the focus of Article 7.2. Now, as I said before the Chancellor, as we said in our skeleton, say to you now, we see both sides of the argument. The appellants only see one, naturally. We, as the trustee, are putting both before you for you to make your decision. And you can choose between them. But as indicated in paragraph 12 of the trustee's supplemental skeleton, which you've read, and as I indicated to you yesterday, a value-neutral solution can be reached either way. And the example I gave to you yesterday on a wholly E&OE basis was I said to you that in prior negotiations, as has been the case in this case, it's been floated that a 17% member contribution rate would be might be tolerable. And as we saw, if the 130% cap is applied under Rule 21.1.2, the member contribution rate would be 13.36%. And so, as I said to you yesterday, it's perfectly feasible marrying the two provisions to imagine a situation where member contributions are 13.36% under 2 and future service benefits are, without suggesting a necessary congruence, well, not zero, my lady.
No, I mean they're reduced.
They're reduced by a little. Yeah, exactly. They're reduced to 13.36 over 17 of their previous level, although one can't possibly, without being an actuary, put that forward as a matter of science. So, that's why, in a sense, we have been relaxed about the issue. Clearly, those who we represent, since we're representing the members here, have an interest in our being insistent on the cut-off being after 2. And as I say, there are perfectly tenable arguments for that. But in practice, what would happen if the cut-off was after 4 is that a value-neutral result would potentially ensue. That's the point. Now, that's all I wanted to say to you about Article 7.
We go on to Article 5?
No, my lord, because there's a couple of points I wanted to pick up with you.
Right. You've got half an hour.
Well, my lord, I've actually if I may say, forgive me, on the chess clock,
yes,
we have got till 11:49.
You have got half an hour, Mr. Green, I'm afraid, and then we're going to have a 10-minute break, and then Mr. Spink is going to have 48 minutes, and then that will be the end of the hearing. So, could you please cut your clock according to what is available?
Well, my lord, of course I will.
Thank you.
Thank you for making that clear now. I will cut my cloth. I've got half an hour. My lord, you're proposing an 11:15 break or an 11:30?
11:30.
Very good. Okay. I want to deal with a couple of points in relation to... Well, okay, I'll deal with Article 5 and then I'll come back to a couple of points.
Yes.
Article 5, this was a subsidiary point in the claim was issued, as is reflected in its treatment in the trustee's skeleton at paragraphs 75 to 81, A10, 148 to 150. And as explained, if your lordship still have the trustee's supplemental skeleton, paragraph 15, A13, 153 to 15, the way that the arguments have developed in this case, the interpretation may be said to have become moot on each party's case. If your lordships kindly remind yourself of paragraph 15. However, to the extent that there is any continuing possible life in the point, the appellant, the trustee's position is this. Article 5A, which is at B11.143, prohibits employers or trustees exercising their powers in a way that prevents a participating employer, which prevents a protected employee participating in a scheme provided by his employer pursuant to Article 4. And as we know, participation means active membership. That's Schedule 11, Paragraph 1.1 of the Railways Act, A10, 108.
Schedule 11, paragraph
1.1.
Thank you.
As the trustee submitted before the Chancellor, prevention of participation must mean both initial participation and ongoing participation whilst protection continues. Article 5A cannot sensibly be said to be legitimating prevention of participation on day 2, so long as the employer had provided admission to an Article 4 compliance scheme on day 1. And that was the main issue before the Chancellor on Article 5A, who decided it in favour of the trustee at paragraphs 118 to 119 of his judgment, with which decision the appellants do not take issue in this appeal. Instead, they may take 2 new points of construction, which, as you see, we accept they're entitled to take before this court, and they reprise what was rather a more secondary point before the Chancellor. Now, as to the new points, first, the appellants say that Article 5A only applies where an employer does something with the deliberate object of preventing protected employee participation. That's their first submission, paragraph 77A of their skeleton, A9123. Only applies where an employer does something with the deliberate object of preventing participation. And the second argument is that Article 5A only applies where the employer's prevention of participation is itself unlawful. That's paragraph 77B of their skeleton, A9123. And then the appellant's reprised point is that Article 5A cannot apply to anything that is done in exercise of a power in the RPS. That's paragraph 78 of their skeleton, A9124. And we say these are not good points. They are addressed shortly at paragraph 81 of our skeleton, and I'm going to elaborate on the answers briefly now. First, as regards the first point, deliberate objective, 4 points. 1. Article 5A could easily have said none of the persons mentioned in Schedule 11, paragraph 7.2 shall intentionally prevent a protected employee from participating. It did not, and we would say with good reason. Point 2. Article 5A is there for the protection of protected employees. The mischief which it is concerned with is prevention of participation, not the existence or otherwise of employer or trustee intentions in relation to that. 3. Similarly, having regard to the mischief, the notion that a protected employee should be concerned with having to become embroiled in the subtleties of the employer's subjective intentions in order to establish a breach of Article 5A is unrealistic. Point 4. Proof of impermissible intention is not a feature of the other protections conferred by the protection order, such as the prohibition on making an amendment which adversely impacts the no less favourable rights of a protected person. And there is no reason why the existence of an intention should be required under Article 5A. You don't need to have an intention to prevent, to achieve an illegitimate result. If an amendment actually does infringe no less favourable rights, it is invalidated. Second, as regards unlawful means, the points are similar to those just made, and again they're 4 in number. First, Article 5A could easily have said none of the persons mentioned in Schedule 11, paragraph 7.2 shall, by unlawful means, prevent protected employees from participating. It did not, and we would say for good reason. Point 2, the mischief point. Article 7A is there for the protection of protected employees. The mischief with which it's concerned is prevention of participation. Article 5A renders that unlawful of itself, the unlawfulness consisting of the infraction of Article 5A. There is no intelligible basis for superimposing a further unlawful means test if the conduct is already independently unlawful. If the conduct is already independently unlawful, then the law would supply a remedy and there would be little point in Article 5A. 3. Similarly, having regard to the mischief, the notion that a protected employee should be concerned with having to become embroiled in issues as to whether an employer's conduct was independently tortious, for example, in order to establish a breach of Article 5A is unrealistic. And 4, point 4, proof of separate unlawful means is not a feature of the other protections conferred by the protection order, such as the making of amendments affecting, adversely impacting no less favourable rights. There's no reason to insert it here. And as regards the reprised point, which I think is now my learned friend's main point, as regards anything done under the rules of the RPS, by definition not infringing Article 5A, anything done pursuant to the rules of the RPS, by definition not infringing Article 5A. Point 1. The whole point of the protection order is that it may constrain the operation of the rules of the RPS. That's what Clause 7H says. It specifically recognises the potential for the protection order having just such an effect. Point 2. In order for the trustee or the designated employer to have power to do something that might be preventative of participation, it must come from somewhere. It is plain as regards the trustee that such a power is going to be one that has been conferred under the scheme or the section. And to suggest that Article 5A cannot by definition apply to such a power is to sap it of the potential for practical operation. And what goes for the trustee goes similarly for the designated employer. 3. It is plain that other provisions of the protection order constrain the exercise of powers under a scheme or section, e.g. the constraint on the power of amendment. The fact that the power of amendment has been conferred under the scheme or section is no basis for saying that the protection order does not apply in relation to its exercise. Just moving on, paragraph 77C to D of the appellant skeleton then goes into contractual arrangements with members. They're obviously completely different. They've got nothing to do with acts, unilateral acts on the part of the designated employer preventing. And so we say that the Chancellor was right that the article would prevents the designated employer and the trustee from setting rates of contributions and including lifting the 130% cap if the consequence is actually to prevent participation, and prevention of participation is the causing of opt-out. And that you can't, for example, say, have the designated employer and the trustees say, okay, well look, we've got a significant shortfall, let's have a 1,000% of section pay rate, and as a result of which everyone opts out, and say, well, that didn't prevent participation, did it? You can't say the opt-out is the thing which can be pointed to, which absolves you of responsibility for what you've done. You've created the situation.
And what do you say about Mr. Speake's point about it's voluntary?
Well, it's not voluntary, is it? We say, well, it's Hobson's choice. Pay 74% of section pay. It's Hobson's choice. And these are protected persons. It's, Hobson's choice for someone who's supposedly receiving protection. It's not a level playing field. Two further subjects, if I'm able to get through them, but one particularly that I'd like to deal with. First, the files handed in overnight. I'm certainly not at the end of the session with the 151 examples of the use of the word determine in the Pension Trust and the rules. Only 22 of those refer to the actuary, and the majority of those 22 concern the usages in rules 20 and 21, which we've been looking at. And in our submission, and I'm certainly not going to it, nothing decisive of this case is to be extracted from going to those 151 references.
Good.
Thank you. So one comes back to the present provisions and what does the word determine mean where used in them. And I just want to pick up on something here, because yesterday, Sir Launcelot in particular queried with me my use of the expression substantive discretion
Yes.
in relation to what the actuary was doing under Rules 21(1), 2 and 4. And I'm told that the transcript records that I used the expression 5 times yesterday. Now, the key passage, if we might look at it, and I just want to elaborate on it so there's no misunderstanding. I hope you've got hard copies of the transcript now.
Nope.
I had, in fact. I'm not quite sure how, but anyway.
Well, that's not. The key exchange is at page 59 of yesterday's transcript.
Thank you.
Page 39.
59. Day 2, page 59, line 20, through to day 2, page 60, line 6. And the context, or part of the context, is seen from day 2, page 57, 18 to 24, where Sir Launcelot had said to me, well, you know, for a trust lawyer, discretions, you tend to think about trustees. And I replied, power holders. And Sir Launcelot said, yes, power holders. And I then submitted at 59 to 60, throughout Rule 21, line 20, throughout Rule 21(1), such substantive discretion involves many and various exercises of professional judgment, which a specialised pensions actuary is well qualified to bring to bear. Indeed, which in his capacity as actuarial advisor, he would be expected to bring to bear in deciding, settling, concluding or fixing a matter entrusted to him. And then I say those professional judgments include making judgments of all sorts of things as to the future. And a related point, just to pick up on it, at page 94, lines 6 to 8, so we've got the complete picture here. Page 94, lines 6 to 8, Sir Launcelot said to me, entirely correctly, why do you say the power to determine? It's a duty, isn't it? And I said, yes, indeed, it's a duty to determine. It's plain, that's plainly correct. Under both 2 and 4, the actuary plainly can't decline to make a determination. He's clearly being empowered to do it. Now, so far as regards...
While we have the transcript, could I just mention for the record that at page 58, line 13, 2 or morality courses should read 2 or more alternative courses.
Now, so far as regards day 2, 5920 to day 2, 66, in case there is any remaining question in your Lordship's minds, may I just say as follows. As we know, the difference between the appellants and the trustee in relation to the use of the word determine, in the second place that it is used, in relation to what the actuary is to do under 2, and in relation to what the actuary is to do in the second limb of 4, the difference between us is that we say that the actuary has a choice to make based on exercises of his professional judgment, whereas the appellant says he has none, save potentially under 4 if the value of the future service benefits exceeds the post Rule 21(1), 2 shortfall.
Yes.
So we say choice to make in all cases. Now, on the appellant's case, the choice falls to be made having regard to the purpose of the rules and of the power conferred on the actuary under them. That is, to make good the shortfall so far as the operation of the rules permit. And as regards that, we say the actuary is to look to maximise contributions received in fact, because only by factual receipt will the shortfall actually be made good. And that, we say, inevitably requires him to bring into account the collectability of contributions attendant on the determinations that he makes. Now, under 2, the second and fourth uses of determination might be said to be joined at the hip. As you recall, the second is the setting of the contribution, determination of the contributions. The fourth is determining the rate and period for which they are to apply. So we say that, that under 2, the second and fourth uses of determination, determination of the contributions and determining the rate and the period for which they are to apply, are in a sense joined at the hip. On the trustee's case as regards this, the actuary is to identify an increase and the rate and period for which it is to apply to maximise collectability. And that does involve the making of choices in his discretion based on professional judgment. He's to identify an increase and the rate and period for which it is to apply to maximise collectability, and that involves the making of choices in his discretion based on professional judgment. Is the rate of contributions best set to have members pay 10%, 15%, or 20%? Is that rate best set as a flat rate, or with an element of back-end loading to gently introduce the members to it so they get used to it, or even with front-end loading so that the pain is short-lived? For what period should the increases be imposed? As I say, short-term so that there's light at the end of the tunnel, or long-term so as to spread the pain. These are all choices to be made by the actuary in his discretion, exercising his professional judgment with the single-minded object of maximising collectability. In all cases, in order, having regard to collectability constraints, best to maximise what is collected so that the shortfall can maximally be made good in fact. And that's 2. And under 4, 2114, the actuary has similarly to be careful to ensure that collectability of contributions is not compromised by any cutback of future service benefits that he may determine, so as to compromise the purpose of maximising the getting in of contributions on the basis that it is only by getting in such contributions that the shortfall will be made good in fact. And in that exercise, and for that purpose, he will need to make choices in his discretion as to which benefits are cut back, accrual rates, basis of salary linkage, computation of pensionable salary, and the overarching purpose in making those choices is to ensure that he does not upset the apple cart and prejudice the collectability of contributions by causing opt-out. Every single one of those choices, every one of which are exercises of discretion informed by professional judgment, which he makes, go to the determination of the issue. And that's what we're getting at. And so when I've said substantive discretion, that's what I'm getting at. The choices made involve exercises of discretion, assessments of the range of what is collectible if contributions are to be increased and or future service benefits reduced, and then a judgment of what is prudent to choose having regard to the overriding object of maximising collectability so as to make good the shortfall. And these, final point under this head, these are not calculations yielding one answer. Different actuaries may properly differ as to whether 16% or 17% of section pay over what period is the sweet spot in relation to this. Different actuaries may properly differ as to the scale and nature of the future service benefit cutbacks consistent with the sweet spot. These are choices. They involve exercises of discretion based on the bringing to bear of professional judgment. That is why I have used the expression substantive discretion. But that, in a nutshell, is our case. And my final point is this. Picking up on Sir Launcelot's questions of me yesterday as to the actuary being a fiduciary or not. The actuary isn't a fiduciary. The actuary is an appointee of the trustee. That is what's provided for under clause 6b of the trustee. It's what it said in 1994 at B432. And at clause 2G of the trustee, 1994 version is at B428.
I was going to ask you about that. That's heading fiduciary duty, and it's to do with the trustee.
Trustee and the pensions committee, but not the actuary, correct. And the current version of clause 6b, as affected by clause 6bb1 at B12, 182 and 184, is to materially the same effect. An appointment has to comply with Section 47 of the Pensions Act 1995, which via regulations requires the actuary to be a fellow of the Institute and faculty of actuaries, and to be an independent person. And as my lady says, clause 2G is still there. Now, point two on this. The trustee's appointment of the actuary is contractual, and the professional fees incurred are provided for as a scheme expense under clause 2C. It's an appointment to a role provided for under the pension trust and operative in relation to a section's rules. Point three. There is no need, and in our view, no warrant, to analyse the actuary's role as fiduciary.
I think we're all agreed on that, aren't we, Mr. Green?
Well, I don't know we are we?
I think it's because of the use of discretion, both by you and by, as a result, by the Chancellor, that the issue about what kind of discretion arose. And you've used discretion again this morning, but I think that when you answered Sir Launcelot's question, first of all, yesterday, you said it's a matter of professional judgment, this is what actuaries do. And this morning you've also said it's a matter of professional judgment, he's got to make choices, actuaries have to make choices, they do so, and you've used the words discretion. But I think that, and that's where I think the seed of the problem lies, but in relation to that, you would be content to say that they are choices made on a professional basis in accordance with proper professional judgment, in the light of the fact that this is a proper professional person who is regulated to an enormous degree and has guidance notes about every aspect of his job. But that's not to suggest that he is constrained in the sense that one actuary may come to a conclusion that another one doesn't, as long as he applies those standards properly.
Indeed, and those choices are discretions. Well, I won't say any more to them.
Please, Mr. Green.
Yeah. Okay, so Ron, I won't say any more to you about fiduciary duty if you don't want me to.
No.
In that case, I'll stop.
Mr. Sawyer?
Nothing to add.
Thank you very much. We will resume in 10 minutes, 11:38 or something like that.
Be back.
I'd like to see more. Discretion.
Pick up this delusional voice again. You all seem so keen on.
I know, yeah, you
Oh, you're not. You thought you were free. Closed the running.
I'm not sure, but she could on the loop. 5 minutes. They're outside here.
Yeah.
One thing. No, I've got that. It's all in my notes. I've got that. This is the first thing.
Yeah, I can actually, yeah.
everybody ready to commence?
Yes, Mr. Spink.
Thank you, Robert. I'm going to focus almost entirely on what we see as the really important issue, which is the discretion point under Rule 21.1.
Yes.
Before I do that, can I clear out the way in hopefully 2 or 3 minutes at the most, perhaps less, what, if anything, remains between us on Article 7 or 5. On
Yes.
Article 7, I maintain the submission that I made to the learned judge, the learned Chancellor below, that my learned friends come as close to accepting our position on where Article 7 cuts in as he can do. He recognises the force of the argument that it cuts in after Rule 21.1.2. He chooses to illustrate the force of that argument through the prism of the words relevant matters, and that is undoubtedly part of the argument. But the particular point that I addressed to you myself in my submissions is Article 7.2b, that the schedule of contributions must take account of accrued and accruing rights, and that can only mean rights that will accrue during the relevant period when the contributions that are needed to fund them are to be paid under the schedule. And that means that it must therefore take account of any exercise of Rule 21.1.4, which reduces the benefit burden going forward. And I note that my learned friend did not address that point in his submission. And I leave my submissions on that there. In addition to the other points that I made about where it cuts in terms of coherence and so on, and I won't repeat those submissions. On Article 5, the short point is that you can decide this appeal, and I respectfully submit you should, in our favour on Article 5, on the principal ground that I advanced to you in my submissions, that where there is an operation of the rules that may or may not be the proximate or other cause, but members opt out as a result of that, that is a voluntary withdrawal, and that is the cause of the non-continued acquisition of pension rights, not the employer preventing the acquisition of pension rights. To answer the question that my Lady Justice Asplin asked of my learned friend just now, is that voluntary? He said, no, it's not, because it's a Hobson's choice. The idea that in order to take the benefit of Article 5, in a situation where there has been an operation of the rules and the member has thereafter gone through the process of withdrawing, where the reasons for that and the question of the extent to which it is voluntary in a qualitative term has to be investigated, we submit illustrates that is not a sensible approach to the construction of Article 5. And my learned friend simply didn't deal with what we say is the telling point, that paragraph 6 of Schedule 11 of the Act expressly, it's 6.2b, expressly excludes from the ambit of the power of the Minister to make an order, such as Article 5, situations of voluntary withdrawal. That point, we say, is the answer. And I am not going to say any more about Article 5 unless you wish me to. May I turn to Rule 21.1? I want to focus principally in the time available on clearly the discretion point. The key battleground, if I may put it this way, in this case is whether you must read into Rule 21.1.2, the relevant determines part of that, and Rule 21.1.4, a power in the actuary to decide the level of contributions that will be made by members and the employer under 21.1.2, and decide the level, if any, of benefit reduction under 21.1.4, without thereby doing so necessarily making good the shortfall in the manner called for under each of the relevant steps. Because on the grounds of affordability or collectability, as my own friend puts it, a lesser amount should be, if I may put it this way, put forward or contributed to the making good of the shortfall called for under Rule 21 than the full value of that shortfall. Now, whether or not you call that a discretion or a matter of professional judgment, it may not really matter. It's a very significant choice that the actuary is being asked to make. One that was wholly absent under the BRPS, and we don't say that just because it was absent there it can't be here, but it is a very significant departure within the rules if it's there from what was present under the BRPS. It changes entirely and gives the actuary a wholly new role. He is capable of deciding how much is to be delivered towards the making good of the shortfall under 21.1, anything up to the full amount, and in particular under 21.1.2, less than the specified floor in 21.1 stem. Sorry, less than the specified cap in 21.1.2. That cap was there for a reason. It's express. Yet, the effect of Malone Friends submissions and the trustee's proposed construction is that the actuary can effectively apply a lower floor, collect less money from the members and the employer than is called for in our submission under Rule 21.1. On any basis, it doesn't make good the shortfall when, if the contribution increases went up to the cap, a significantly greater contribution would be made than provided for under the trustee's construction if the actuary decides to exercise this power, this choice in the way that I've described. In addition, he has control, as I say, not only over how much funding is delivered through Rule 21.1, he has control over benefit reductions. On any basis under this rule, benefit reductions are part of the mechanism provided for in this scheme. It's perhaps an unusual and an old-fashioned way of approaching funding it's notable that in pilots, I'll come back to that briefly at the end, there was a shared cost rule there, as the lady will recall, which imposed an obligation on active employees to contribute expressly, it said, up to 100% of their pensionable salary. That was the ceiling on them. However, there was no benefit reduction element added in to that scheme. Here, there is one added into the scheme as a mechanism for delivering funding under Rule 21. We say that the purpose of Rule 21 is to use those mechanisms to the maximum extent possible to provide that funding, which does not sit with the actuary being able to decide whether or not that should happen at all, giving him, as I say, not only control over the amount of money that comes in terms of contributions, but also over the ongoing benefit design. One we submit must look very hard to try and find if the drafting of the rule or the surrounding circumstances call for that. My learned friend's submissions rely very heavily on collectability. The actuary's task is to set determine a contribution level. As it happens, if he decides to determine contributions at a lower level from a member's perspective in order to make them, in his view, more likely to be collected, that also means that the employer pays less when there is no question about the collectability of employer contributions. And absent Article 7, in a situation where there are no protected persons, that means the rule is not being used to its full advantage. There's no balance of cost obligation under the rule, and the employer is not being called upon for the amount that the rule specifies it should be called upon, we say, or can be called upon, as they say. That, we say, doesn't make sense. It's there to deliver funding, and in fact it isn't going to deliver funding at all if the actuary starts the position at a lower required contribution rate on the basis of some notion of collectability in relation to one half of the team, if I can put it that way, that has to contribute, employer and members. And the collectability point goes further. If my learned friend is right, Rule 21.1, absent a balance of cost sweep-up contribution obligation, which is the position under 21.1 as originally drafted, and the balance of cost obligation was brought in 2006.
By which you mean in little 3?
In little 3, but only operable in the situation of opt-outs. All right? Now, I'll come back to that particular point in a moment, but in the context of that rule, leaving aside Article 7, my learned friend's theory breaks down, we say, because the actuary makes successive determinations, valuations, once you get to the extreme and somewhat terminal state that this scheme is in. It's terminal because it cannot deliver funding through Rule 21, either by contributions or benefit reduction. Everybody accepts that. Even on our construction, it can't do that. Up to the 130% cap and full benefit reduction doesn't deliver the full amount. There's a gap at the end of that on any basis. That gap on learned friend's construction and ours cannot be at that valuation filled through 2113 because there are still members in pensionable service.
So why are we here?
We're here. We are here because of benefit reductions. The real issue here, I think, is whether or not, whether you have Article 7 or you don't, one of the steps that has to be gone through in the process is a mandatory determination of reduction of members' benefits. That's why we're here. If members have already opted out, there's no problem. 2113 would come in and provide your balance of cost provision. In a case where there are protected persons, Article 7 does that. And it's capable of doing that at an earlier stage. You don't have to have had opt-outs for that gap to be filled once you've been through the different steps. The real question here is whether or not you can construe Rule 21 1 and perhaps Article 7, depending on the cut-in point, to allow members to continue in pensionable, in accruing future benefits indefinitely, limping along, the scheme limping along, in a non-Article 7 case, without any ability to get balance of cost obligation contributions from the employer. The longer members are enabled, despite the fact that it's reached an extreme state where it cannot support ongoing accrual, or indeed fund the deficit, the past service deficit, the longer they are enabled through the actuary's discretion, either in relation to how many contributions they should pay, what rate of contributions they should pay, or in relation to whether they should have their accrual cut or not, the longer the day is put off when the rule can deliver a balance of cost. And by definition, there's only so much funding under the trustees' construction that Rule 21 can deliver in these more extreme situations. Rule 21 has operated, we know, perfectly satisfactorily for most of the life of this section. Even the 2013 valuation and put forward tolerable contribution increases for members and no benefit reductions. Even the slightly higher proposed figure of 17% that my learned friend mentioned in discussions and negotiations has been regarded as tolerable. The situation now is that Rule 21 cannot cover fully the funding of the scheme. And if the trustee's construction is right, and it doesn't matter how hard the actuary tries to keep contributions affordable and benefits as high as he can under the trustee's construction, it doesn't matter how hard he tries to do both of those things, he will not deliver through Rule 21 itself all of the funding that the scheme requires. And that is the situation that the Rule 21 effectively contemplated, ultimately, whereby once all the contribution increases that could be provided under 2112 have been delivered up to the cap, that's what it says has to be done. And arguments of collectability don't help in the long run at all. And once benefits, sadly, but foreseeably, have been reduced to zero, the likelihood is that members will opt out. Now, in the original version of Rule 21.1, there was no 21.1.3, but presumably in 2006, which is after the scheme closed to new entrants, and therefore the shrinking size of active members was perhaps more foreseeable, 21.1.3 was brought in, recognising not only that members might choose to opt out for other reasons, but that ultimately the scheme might reach a position where they would want sensibly and need to opt out, and recognising that in that situation a balance of cost obligation on an employer would be required. And we say that the discretion, the power, the choice that is given to the actuary may keep the members tolerably happy if exercised in a certain way for a certain amount of time, but ultimately that problem will become insurmountable. Now, in the Article 7 situation, which the drafter of Rule 21.1 would no doubt have had in mind, the problem is ameliorated much more easily because there is a balance of cost obligation that sits behind the scheme. And if at any stage through the proper operation of Article 21.1, insufficient funding is delivered in terms of the figures that it generates, the contribution rates that it generates, and the benefit reductions that it generates, that immediately, without having to wait for all the members to opt out and therefore do it under 21.1.3, comes in and gets funding in when it's needed to a sufficient level. But the fact that that is available under Article 7 doesn't mean that it should be made available without applying each stage of the rule first. Because absent Article 7, that is what you have to do. And there's no need to construe 7 in a way that has that effect, nor is there, for what it's worth, any need to construe Rule 21 in a different way than that which you might otherwise have done because of the absence of Article 7. Building in the discretion that my learned friend calls for does not solve the problem of funding the scheme. It may put off for some time the inevitable endpoint, sad though it is to acknowledge, where the scheme cannot deliver sufficient funding for its past service deficit, much of which has got nothing to do with these active members, such that it cannot rationally support their ongoing accrual.
And how does that factor into the construction exercise? Is that a purposive approach?
That is a purposive approach. Yes, I think that's probably the correct way of describing it. Such a discretion.
Looking back and standing back at the beginning rather than now when we're all going, not enough money. You're saying, nevertheless, at the beginning, one would look at this and think, what is this clause trying to rule, trying to deliver? and it has to cover this sort of situation. That's what you're saying.
Yeah, that's absolutely right.
Okay.
And I make the other the following additional points, which are focus more on the specific wording of the rule, without focusing on the meaning of the word determine as such, but the context of where 21(1)(2) and 4 appear. It's a key point, we say, that under 21(1) stem, the arrangement that the employer and the trustee may come to is an arrangement only to make good the shortfall in full. If we look at 21(1), if an actual valuation of the section by the actuary shows, it's B13, page 218. If an actuarial valuation of the section by the actuary shows that the section assets, together with the future income and future contributions, etc., are unlikely to be sufficient, then paragraph 1 below shall apply unless the designated employer and the trustee agree within 6 months of the signing of the value arrangements to make good the shortfall. And unless that happens, the shortfall shall be made good in the following way. We say those are mandatory words, and it doesn't leave it open to the trustee and the employer to deliver less funding under Rule 21 than is being called for expressly there. If they purport to agree an arrangement where they will only cover 50% of the shortfall, that doesn't qualify because the actuary has to be able to form the view that any remaining shortfall is trivial if 21(1)(2) is not to come into play. And it's not a cumulative process whereby you have an arrangement that deals with part of it and then you go to 21(1)(2). Nobody contends for that in this case. It's all or nothing under 21(1). And if it's all under the stem, if it's all or nothing under the stem, then there is no basis for concluding that it's not all or nothing under 2 or 4. They are all or nothing elements of the same overall mechanism. It would be very strange that absent an agreement between the employer and the trustee to make good the shortfall in full, the actuary could then step in and only make good the shortfall to a certain amount by departing from the floor required by the cap, or to make good the shortfall even less than the rule is capable of delivering. That makes no sense, and it is not in any way, we say, indicated by the language used in 21(1)(2) as determined by the actuary. Now, clearly, elements of professional judgment are involved in that key determination, but not the very significant additional exercises of professional judgment that Malone Friends construction calls for about what is or is not affordable for members. A very difficult judgment to form. More importantly, how is he, if at all, to take into account the interest of the employer, which knows under the express terms of the rule that the floor for its contributions under 21(1)(2) is 130%, and it can rely, we say, on the fact that contributions will be delivered under 21(1)(2), at least up to that a floor, and that gives a reliable source of funding, so long as there is an ability on the part of members to meet their share of 40%. if sadly we get to the stage in the scheme's life where the deficit, the past service deficit, which is the problem here, is so enormous, and there are so few active members left to service it that they cannot meet that 40%, then the scheme contemplates opt-outs as the rational decision to make at that stage in the life of the scheme, and 2113 is, in part at least, a response to that. The same point goes for 2114. The key words are benefits of members in respect of future service shall be reduced. Shall be reduced. For the same reason as it is wrong to suggest that 2112 can deliver anything, can be have as its purpose and target the delivery of the full shortfall, as STEM did, the same goes for 4, and the wording reflects that, shall be reduced. And the bit, if I may say so, that the designated employer and the trustee have to agree is the reasonable basis of that full reduction, which is an issue in itself for the reasons that I've already submitted in terms of how one divides up the benefit reduction. Originally, this rule contemplated that being the end of the process in terms of reduction benefits. The designated employer and the trustee were required to reduce benefits to the full extent, and they were given the ability to agree how reasonably to do that. No doubt it was not given that construction of 2114 thought that that posed a particular problem, given the task assigned to the employer and the trustee under 2114, in certain circumstances, unpleasant task, but nonetheless the task assigned, agreeing how to actually implement that on a reasonable basis might have been thought to have been something that the employer and the trustee would readily be able to reach agreement on. But in the event that that doesn't prove possible, by amendment, the actuary taking over that task was introduced, a sensible amendment.
I think it follows from if you're right, doesn't it? That the deficit figures are so huge that the calculation under 4 is that accrual of future benefits to active members immediately comes down to 0, doesn't it?
Yes, it does. It does. Yes,
Yeah.
it does. And it could have, along the life of the scheme, as my learned friend said, it could have been a situation where minor adjustments might have, tolerable minor adjustments might have been undertaken, which didn't naturally cause members to opt out. But in this somewhat endgame situation, it has to be full reduction. And that is
everyone will, the 29, 25, whoever's left will opt out, giving whatever notice is required, and then 2113 kicks in.
Well, it does if they're not. It does in a scheme where there are no protected persons. In this scheme, my lord, where there are protected persons, Article 7 applies, and will involve that process of balance of cost obligation contributions from the employer taking place immediately at this valuation. The problem with 2113 is that it doesn't kick in until everybody has actually left pensionable service, which is after the effective date that we're talking about. We're agreed on this, my lord. In the valuation that we are contemplating, the present valuation, those members are in pensionable service, and their benefits and their contributions under 2112 fall to be taken into account in the prediction that has to be made, the long-term funding prediction that has to be made under Rule 21.1. That's clumsy it's clumsy, because if those contribution increases are indeed put into effect and the benefit reductions are indeed made, it's only then that they will actually decide to opt out, and that's too late for 2113 to come in at this valuation. That's why Article 7 is a much more palatable answer to the problem in a situation such as this scheme where there are protected persons. But absent protected persons, if this is we don't know whether the schemes that have recently taken up shared cost status without protected persons, what version of the rules they use. If they have a 2113, they have a balance of cost obligation in an opt-out, after an opt-out situation. If they don't, then they won't. We don't know. But certainly in this scheme, that's the position. And we urge the court, as I'm sure you will not, to be over-influenced by the extreme situation in which we now find ourselves, which means that the operation of the rule does generate the sort of contribution level that's unacceptable to members, to suggest, to drive one to a conclusion that there must be a discretion in the actuary to protect them from those affordability concerns. It would, pro tem, and very much only pro tem, mitigate the effect of those contribution increase requirements and benefit reductions, but that would not deliver the funding to the scheme that the rule actually calls for. And ultimately, the important thing for any scheme is to ensure that adequate delivery of funding is provided to cover the past service deficit. Many schemes are unable to survive with ongoing accrual. It's just the way things unfortunately work, and the significant requirement in terms of funding that is recognised by this rule, because it's a very key component of Rule 21, is the past service deficit, which and one can quite see why active members at a certain level would take the view that they should no longer be contributing to that past service deficit, which doesn't, in the vast majority of the amount that is encompassed within it, relate at all to their own past accrual. They indeed need their past accrual to be protected by funding. And it's not protected adequately by a rule that operates with the discretion in the actuary that allows for collectability to be the key, if there is no balance of cost obligation that bites. And as I said, in the rule itself, without protected persons, it doesn't bite until after opt-out, which recognises the very situation that we are now contemplating. And however much one tries to read into the word determines, that problem is not overcome. And determines, we all know, is capable of meaning an exercise of professional judgment, of all sorts of complexity or simplicity, from indeed the actuary needing to undertake skillfully and with professional skill and care necessary calculations at one end, to potentially a significant choice involving not only the interests of members, but the interests of the employer at the other end of the extreme. So the mere use of the word determine doesn't tell you where you are on that spectrum. I'd like to deal, if I may move on from that principal submission about discretion to some particular points, and I'll deal with these as speedily as I can. I want to deal with my learned friend's point 13. For your reference, it's yesterday, day 2, page 106, line 25. It relates to Article 7.5. My learned friend says that Article 7.5 supplies a material point in relation to the construction of the actuary's powers of determination under 21.1.2. So he's using it to read back into Rule 21. Obviously, that doesn't work in a scheme where Article 7 isn't there. But putting that point aside, he made a number of assertions about how we put our case, which do not entirely reflect what we in fact said in our skeleton at paragraph 58.2, which is at A9119. I'm not going to ask you to go to it now, but note that we said that 7.5 requires that the advice be supportive in the sense of confirming that by proceeding, the trustee will not be ignoring any relevant consideration or giving weight to any irrelevant consideration, actuarially speaking. And this is in the context of, for example, a Rule 21.1 STEM agreement the trustee may be considering entering into with the employer to increase contributions or reduce benefits, or indeed making an amendment as well to have that effect. It was suggested that we were saying that the actuary's role was to arbitrate whether relevant considerations have been taken into account. That's close to what we say, but we did not use deliberately the word arbitrate. It's an advisory, a supporting role, not an arbitral role. He took issue with our wording at the end of the paragraph in the bit I've quoted, actuarially speaking. He said that that's just a rewriting of Article 7.5 because our actuary's role under that provision is not just by reference to actuarial calculation. We never said it was just by reference to actuarial calculation. Actuarially speaking means giving advice on points that he is able in his skill and experience to be able to give. His main point is that the advisory role for the actuary includes, and this he says is illustrated by 7.5, being able to take account of affordability and value for money. He says that that must be the case in the Article 7.5 situation because the trustee can take account of affordability and value for money under Rule 21.1 STEM. So therefore, he must be able to advise about affordability and value for money at the STEM stage. And that should therefore be seen as carrying over to his role in 21.1.2 and 21.1.4. The short reply to that, the short answer to that, is that the trustee in its role under 21.1 STEM cannot take account of affordability or collectability if by that is meant agreeing with the employer for affordability reasons on the part of the members to deliver through the arrangement less than the full value of the shortfall. I've already made the point why that is. It's fair to say that the trustee may well want to negotiate with the employer using a concept of affordability in order to try and get the full amount that needs to be delivered under STEM and a STEM arrangement tilted towards the employer, more than 60%, to remove to some extent the 40% burden on the employee, on the member, and one presumes that that is what has happened in previous STEM arrangements, not the ones that Malone Friend has told you about, which we haven't been able to scrutinise, but certainly it has not been suggested that in those other cases where STEM agreements have meant that the full waterfall hasn't had to be applied. The full value of the shortfall has not been delivered by STEM. So that point, with respect on that analysis, goes nowhere. And 7.5 does not assist in the construction of 21.1 in the respect contended for by my learned friend. Next, my learned friend's point 17. This is about the BRPS. We accept, of course, that just because something appeared in the BRPS rule, it doesn't mean that the RPS rule must be construed to have the same effect. Of course not. That's never been our case. But it is a legitimate question, given the starting point of the BRPS, to ask what the drafter of the RPS SCA rules and the protection order was trying to achieve in terms of the balance between the RPS rules and in particular Rule 21 and the protection order, in particular Article 7. There is no balance of cost obligation in the RPS rule in the same way as there was none in the BRPS rule. The solution was to provide that in the protection order. Subsequently, it was realised in the case of this particular Atos section that there may be a need for some balance of cost obligation to cut in when there are no members left. That was a design choice that the draftsman made. That's a general point about the BRPS. It goes no further than that. But there's a particular point that my learned friend made to try and distance the structure of the RPS from that of the BRPS. And this is his point 17, a part of his point 17, at page 145, line 9 forward on day 2. He said that the RPS was a fresh start, and one of the points that he made was that BRPS Rule 45.1 makes the following statement about the valuation report that should identify the shortfall. The report shall state whether the assets of the scheme, together with expected future income, are likely to be sufficient to meet the benefits as they fall due. We don't accept that the point that he makes, that future income excludes future contributions, is correct. It is true that the only reference in 45.1 includes future income. In RPS Rule 21, it expressly includes future contributions, but it makes no sense in the context of what is trying to be achieved in the BRPS, as it is in the RPS, to exclude future contributions from the equation. And the future income reference in the BRPS must be construed as including future contributions. I'll leave that point there. I need to deal with one important point that my learned friend made, and which is the other point of difference he identified between us in relation to Article 7, which is his suggestion that what we are trying to do is take credit for things that we should not take credit for. This is day 2, page 47, line 17 forward. We don't understand where my learned friend gets this from. Our case at bottom is that we accept that the funding gap will need to be filled under Article 7, but that the reductions in future service benefits must take effect under 21.1.4, and thereafter the balance is swept up by Article 7. There is no double counting point here. the contributions which the actuary will put into the schedule of contributions can take account of the future contributions that he doesn't think will be collected because members may opt out, we accept that at this point in the exercise that the actuary is undertaking, at this point, he could and indeed should prudently look forward to see what will happen after the scheme that is generated by Rule 21 is put into place. And if there is going to be a significant fall off in member contribution rate, that will have to be fed in, and it will be fed in to be paid by the employer. And the schedule of contributions under 7.7 will take account of that. We're not trying to take credit for anything that we shouldn't take credit for. There's no double counting. That's the way it sorts itself out.
So, you say you're not taking, you're not diminishing the amount which is it ends up in the to be picked up by the contributions, because if the actuary thinks that they're never going to be paid, he's entitled to do that in his schedule. But you do say that 7 comes after little 4, and so you are, in Mr. Green's terms, taking the benefit of reducing accrued benefits going forward to 0.
Well, the scheme...
Using Mr.
Well, I'm not sure that was the credit that he was chastising me for trying to take.
No, both. He wanted to chastise you for both.
Oh, yes, okay. Yes,
Stand chastised.
I
The contributions, I understand what you're saying, but in relation to, by saying that 7 comes after little 4, you are looking at a situation in which the gap to be filled by 7 takes account of the fact that the benefits have been... you do.
Yes.
Inevitably.
Absolutely. That's not double counting. It's just the way the rule operates, and that gap will get filled. No.
But it's a lesser gap because of little 4. I think we're on the same wavelength.
We're on the same wavelength. Exactly, Milady. Thank you.
Reached the time limit.
We've really reached the time. I'm just going to see if I can say anything in the remaining 2 minutes, my lord,
Please do.
that I feel is important.
Right.
I've nearly reached the end of my notes, and I just want to make sure I cover them off. 2 points very quickly. We agree that this doesn't turn, the discretion point doesn't turn on whether or not the actuary is a fiduciary or not. One could argue that to some extent, but if he's not a fiduciary, the question is, in other words, put it a different way. Our case that there is no discretion doesn't turn on whether he's a fiduciary. I don't think Mr. Green's case that there is one turns on whether he's a fiduciary. Interesting questions arise if my learned friend is right about how this complex power that affects the interests of the employer is to be exercised by the actuary, and how that might be challenged, if at all, by the stakeholders such as the employer or the trustee. But that's a point for another day, if it's right that he has that choice, discretion, power. Equally, our case on 2114 doesn't turn on whether it's a discretionary trust or not. It doesn't turn on whether the employer is controlled by Imperial or not. That may be the other way of looking at it. The key point is, what does it say? It says shall, and I've made my submissions about that. I'm going to end just on my learned friend's divorce from reality point, based on pilots. The point is very simple. It's a totally different case. I've already said one of the reasons why it's a totally different case, namely an entirely different, albeit with some similarities in part, in terms of the contribution structure. There's no benefit reduction element, as I've said, but it's completely different for another reason. there was no challenge to how the shared cost rule would work in pilots if that were the only rule or the only source of funding. That was taken as read as being a shared cost rule that under its terms could impose on members up to 100% of their pensionable salary. And in a context of a huge deficit, that could be extremely onerous. But that was what the rule said, and nobody said it didn't say that or operate in that way. Part of the case was about whether trustees could amend the scheme to introduce new contribution powers on additional, I'm going to call them employers, they weren't all technically employers, it doesn't matter, employer status sponsors, those who had previously had active members in the scheme, to try and mop up this vast deficit. Partly because they didn't want to have to rely on the shared cost rule alone with the burden that would place on the members. The other part of the case was analysing the effect of the statutory regime in a situation where you have a contribution rule that on its own would not deliver sufficient funding, partly because of the cap on members' contributions of 100%. And the issue was not how all of that was to be operated, which is what the issue is in our case, but the issue was whether the regulator, when it comes to try and administer the statutory scheme, was bound in the scheme that it devised to faithfully require the shared cost rule to have its full effect. That is what was described by Mr. Justice Warren as divorced from reality, because it was clear that if that were the approach that the regulator took, members would leave, and so that stream of income would dry up. At the regulator's stage in the process, that's clearly a very relevant consideration. At the Article 7 stage in our scheme, the actuary, as I have said, can consider the issue of collectability and what to do about that problem in the Article 7.7 schedule. That's as close as it gets. It doesn't help.
Thank you very much.
It boils down to a sound bite, I'm afraid, taken from that case, out of context.
Thank you very much, Mr. Speaker.
I thank you for the extra 2 minutes. Whether they were worth it or not remains to be seen.
Right. Thank you all for your submissions, both oral ones from the leaders and the written ones from the juniors and backup teams. We will, of course, reserve judgment. We'll send out, it won't be till next term, but we will send out a draft judgment in the usual way. 2 points to make Chancellor familiar with both. First is the draft judgment is sent out not for the case to be re-argued, but just for the correction of typos and manifest errors of fact. And the other is that it's subject to the confidentiality obligations identified by the Master of the Rolls and the Counsel General for Wales's case. You know all that. Thank you all very much for your assistance.